Could I just have a show of hands, just so I know what I'm dealing with, how many party wall surveyors we have in the room? Probably about half. And other disciplines of the architects, engineers, others. What are the others?
Surveyors.
Building surveyors, home purchase surveys, like myself, and that's the sort of a background that I certainly came into, and it was through that as a building surveyor that I discovered the Party Wall Act and decided, oh, that's something I want to get involved into, because we're sitting in people's back gardens and we spot these things, and it's natural that we want to be have a little bit more information about them. So I just wanted to sort of look briefly at the Party Wall Act, just to sort of set the scene before we sort of move on. And for the Act to be engaged, it basically means we're in dispute. Somebody wants to do some work, somebody's affected by those works, the building owner, the adjoining owner, and the Party Wall Act regulates what can and can't be done. So the purpose of the Act, as you all know, those of you involved in it, is to allow the building owner's work to proceed. It's not there to stop him, it's not there to be a hindrance, it's to allow him to get on with it, and it's to allow him to get on with works that otherwise would actually be a nuisance under common law. That might be trespass under Section 6. It allows you to go onto your neighbour's land to build the excavations. Under Section 1, it allows you to go onto your neighbour's land to appoint a wall. And without the Party Wall Act, you couldn't do those things. Okay, it would be trespass. It would be a nuisance on your neighbour. So it's a very clever piece of legislation that lets that continue. And obviously the first thing that normally happens is surveyors are appointed. The normal course of events is that the building owner serves a notice on the adjoining owner saying, this is what I'm going to do on my land or on the boundary of our lands which affects you. A dispute has arisen, otherwise there'd be no need for surveyors. They wouldn't be appointed. It would just be one owner telling the owner what he's doing. And the adjoining owner always has the option. We serve a notice. On the back of that notice, there's always a little acknowledgement form that says, please reply in the following format. You've got 14 days under the statute. And you can either dissent to my works and appoint a surveyor, or you can consent. Now, you can consent and you can say, well, look, I'm very happy with your works. There's no real impact on my property. It might be, for instance, that you're just doing Section 6 works, you're excavating 1.5 metres inside your own land, you're building a rear extension. The chance of damaging next door's property, pretty remote. So you could just tick the box and say, yeah, get on with your work. That's no problem. Or you could dissent. And you could say, do you know what? No, I want a surveyor. And I often say to people, that's fine, because what in essence you're doing is you're setting up a dispute resolution mechanism for the future. At this point, there is no dispute. There's been no damage caused. No works have started yet. So you haven't fallen out with your neighbour, but they've wanted to appoint their own surveyor, which they're entitled to do. And then obviously that triggers that the building owner now has to go and get his own surveyor, because up to this stage, you may have been instructed by the building owner to serve notices, but you've purely done that in your capacity as an agent. You're not appointed yet under the Act because there is no dispute.
Just one point.
Yeah.
At that point, who's responsible for the payment of the?
If you're acting as an agent, your instructing owner pays your bills.
So if you dissent.
If you dissent, then the Act is invoked, and at that point, the building owner is responsible for the reasonable fees of both surveyors.
Of both?
Yeah.
Right.
His own surveyor and the adjoining owner's surveyor. And I should say reasonable fees. That's not just a blank cheque, for surveyors to go off and...
I may be jumping kind of a bit now,
yeah.
but if the party wall notice is not served and works...
We're going to come on to that. Yeah. No, we're going to come on to unlawful works because I want to sort of work through the different scenarios, and you're quite right to raise that. So you've set up this resolution, so the dispute resolution mechanism, which in fact the award is. It sets out what will happen in the event of a dispute, and the dispute is typically damage to the neighbour's property. But it's for the future, because it hasn't happened as yet. And in some instances, you might think, that's a wee bit OTT. But in other instances, you might think, no, that's the right way to go. Because actually, accompanying that simple Section 6 notice that said he was excavating way over, 2 metres away from your property, over there, behind the fence, he was also had a Section, say, 1-2 notice, which he wanted to build a new wall astride the boundary. Now, that requires consent from the adjoining owner. So if you receive that, and you go, don't really know what that means, but I like my neighbour, he's a good guy, I'll just take consent. He's just building a wall, that's fine. You go off on holidays, and you come back and you find he's built his wall 6 inches into your property. And you're going, hold on, that's not what I bargained for. So in those instances, yes, some good advice from a surveyor before the fact, would really be beneficial. So not everybody just dissents because they don't like their neighbour. Sometimes I say to people, why did you dissent? And it can range from, have you seen that Porsche in the front of his house? The guy's a knob, yeah? Not letting him get away with anything. Or it could be, because I'm really concerned his works are going to damage my property. I'm really concerned that his rear extension's actually on my side. So there's some very good reasons for getting that initial advice. So as I said, the building owner gets some rights under the Act that he wouldn't normally have, because they'll be governed by tort, by common law. And the Act allows him to do certain things, but obviously to benefit from those rights, he has to play the game. He has to follow the procedure. He has to serve notice. He has to engage in the Act, get the adjoining owner to also engage. And obviously there's mechanisms through Section 10 to make sure surveyors are appointed when they're supposed to be appointed so as not to delay the building owner's works. And ultimately, early intervention, early advice, and good education by us party wall surveyors telling people what their rights are can avoid future disputes. Simple things that we can say, did you know this is the effect of those works? Did you know you have the right to do this? That is a garden wall. Your neighbour has rights, but you also have rights. Just a little bit of education, just a little bit of explaining can actually get those agreements written down early doors and avoid future disputes. So obviously you're dissenting, that triggers the Act, because you want to have that future proof. You want to have that ability to solve problems in the future. But if you just merely consented, that's not the end of it. That doesn't mean your neighbour can go off and do what he wants now. The Act is engaged because notice has been served. Surveyors haven't been appointed, but surveyors only need to be appointed when there's actually a dispute, when something's gone wrong. So you can decide to consent to the works and just sit back. Say, maybe you could consent and say, but I want a schedule condition. Now that protects both parties, because obviously there's no spurious claims from the adjoining owner of, did you see that crack up my wall, you caused that? Because you can simply turn around to the photograph your surveyor took and went, that was always there. And they go, well, yeah, fair enough, I just hadn't noticed it. So, I often say to people, well, just consent. The works are pretty minor. They're not really affecting you, but notice has been served, the Act's been invoked, you are protected. Consent if you want to. And then later on, if something happens, you can at that point appoint a surveyor. And then the building owner must appoint a surveyor. A tribunal is formed, and that's either you concur in the appointment of one surveyor, an agreed surveyor, or the two parties both select a surveyor. Those two surveyors select a third surveyor, you have your tribunal, and you have your point to push on any further disputes. So you're not actually losing anything by consenting. You're just pushing back the potential of a problem until the actual problem's there, or the resolution of a problem until the problem is just there. But it's not always that straightforward, because sometimes we have to ask ourselves more questions than just, my owner wants to build a rear extension, that's a bog standard. Section 6 for excavations, Section 1 because he's building his wall on the line of junction, Section 2 because he's going to be taking out some chimney breast. Sometimes it actually requires us to go on site and have a look to see what's happening. I'm as guilty as this, as I'm sure we all are, of looking at the plans and going, yeah, that's fine. Plans very rarely show what's going on next door. The architects come out, draftsmen come out, done up the plans, for that person's property, they haven't really bothered looking at next door. You know, they've drawn this as the corner of their rear wall, and that's probably the height of it. So sometimes it's really good to actually go out and actually see what's there before you give any advice. Now, I know in very straightforward cases, you know, sometimes serve notice, worry about it later on. Okay, and we all do that. But certainly in more complex cases, it's worth having that site visit to actually see what the relationship between the two properties are and make sure you're giving the proper advice. And in fact, can you serve notice? Or should you just be holding back and going, before I serve notice, I would like you to resolve a few things here. I would like you to have a look at a few issues that need to be sorted out with your neighbour before we go forward. And it will help us have a smoother ride further down. And that's really the crux of this, that there are further areas of expertise that are required. And I'm going to be speaking today a little bit about boundary disputes, a little bit about adverse possession. I'm not going into any huge detail in anything. The law, if you're interested, is in the handout. So I'm going to be skimming over that and really more interested in the sort of the case studies, what I saw. They're all areas that I've looked at the last year or two, what my resolution to it was, how we move forward, and I'm really interested to hear from you guys what you would have done differently. Or do you agree that I did the right thing? And of course, none of us work in isolation. So if there's a dispute, there's two people to that dispute. And quite often, my opinion doesn't matter. But it's my opinion together with the opinion of another advisor or party wall surveyor and the compromise that we reached. And ultimately, the parties decide. Doesn't matter what we say. Doesn't matter what the other surveyor says. If the two owners go, bugger them, let's go and have a pint. I'm going to do this, you're going to do that. Do you agree? Shake hands, done. Okay, you can go home. Okay, you're not there to cause problems. You're just there to try and prevent them. So that leads on to your question about unlawful works. And this is quite often I'll get a phone call and say, Chris, could you come out? My neighbour's going to do some works. And you know, I think they should have engaged the Party Wall Act from what I read online. Not 100% sure. And then I go, have they started? And they say, yeah, I think they have. And I go, okay, well, you know, maybe the builder's on site. I'm only interested, as you are, in the notifiable works. So there's a stack of things the builder can be doing on your neighbour's property, and what they do in their property is their business and none of yours whatsoever. So we'll just we'll look at the potential notifiable works, and I'll tell you whether they should have had notice or not. And sometimes I go out and I see a 6-foot trench right up the side of the house, and I go, whoops, yep, that definitely needed some notice. And it's a risk. There is a problem here. But if the works have already started, the issue is, the general rule is, the Act is not retrospective. There's nothing actually in the Party Wall Act, if you read it from cover to cover, that actually says, stop, rewind, and we'll do this again, we'll start again, as if that had never happened. It has happened. It's over. It's finished. Those works, if they've been filled with concrete, it's done. Okay? And the Act has no part in it. But those works are unlawful. Now, the reality, unfortunately, is if you want to go to court and argue your case in front of a judge that your neighbour built his rear extension, didn't serve you notice, he's going to go, well, was any damage caused? No? Then what are you here for? You obviously wouldn't even get that far. But, you know, there has to be damage for you to be able to take an actionable case. You know, otherwise, yeah, your neighbour's a plonker, but there's not much you can do about it. Your relationship's gone, unfortunately. This quite often happens, and that's really sad because everybody lives cheek to jowl. And, you know, communication is key. So you've obviously, though, you do have a remedy, because if the works are halfway done, the trench is there but it hasn't been filled, and you're worried that, you know, if he hasn't served notices, what else has he not done? Has he got plan permission? Has he got building control approval? Is the building control officer going to come out and look at this trench? Is it the right depth? What about that oak tree? You know, has he gone deeper because of that? Does he know about this on my property? So you may be very concerned, and your remedy is to take out an injunction. Now that can be a very, very expensive journey for the building owner, because the joining owner, without any notice, takes out an interim injunction, and they will stop work. Because they'll go, whoa, everything stops. Builder's off site, but he's going to charge away. It's not his fault. Then you'll have a hearing. You'll go along. It'll be decided whether or not that injunction should remain. It may be that the injunction remains to such a stage as the notice has been served. But of course, with service of notice comes timescales. For Section 2 works as 2 months. For Section 1 and 6 months, it can be 1 month or just notice. And then, of course, you can sue for damages under nuisance, but there has to be damage to sue. So you could be left with no remedy. And while the Act is often criticised for having no teeth, it's we just discussed, it's not retrospective, there's no penalties, you don't get a fine for not adhering to it, and many people think, well, if I do it and get it done and get it finished, that's it, I'm in the clear. You're still breaking the law. Your works are unlawful because service of notice is mandatory. The law says if you're doing work and that work requires the service of notice, that is mandatory. You don't have an option in this, you must do it. Now, there are possibly other ways of looking at this because the adjoining owner can also appoint a surveyor. So if the building owner has run off and he's going, where's my notice, where's my notice? And I had a case recently where notice was served, it wasn't dated, it wasn't signed. And another notice was served and it was deliberately vague. And the building owner just constantly, because he's a very intelligent man, constantly served notices, go, I'm sorry, knowing they were all invalid, knowing they weren't worth anything, so the Act wasn't invoked, until he got his work done. Because he just thought, well, if I continue with this, I just keep bluffing for 2 or 3 weeks, the foundations will all be poured and I'll be in the clear. But the adjoining owner can also appoint a surveyor. Just running through the law. So if either party to dispute refuses to appoint a surveyor, they can then appoint a surveyor for the building owner. Okay? So it doesn't have to be the notice that comes first. We had an argument actually about that, not an argument, discussion about this last week in Basingstoke. Because my contention is that Section 1010 of the Act as it's written now, which has replaced a previous section, the word notices has been removed. So it used to say that a dispute could only be taken forward under the Act if a notice had been served. But they took the word notice out. And it now reads, the agreed surveyor, or as the case may be, the 3 or the 2, shall settle by award any matter which is connected with any work to which the Act relates, which is in dispute between the building owner and the adjoining owner. So it doesn't say only if the building owner has actually served a notice. So Alex Frame was in attendance last week, who's the president of the faculty of Party Wall Surveyors. I'm sure all of you that are acting surveyors are aware of him. And he said no. He said no notice, no Act, full stop. That's the end of it. They haven't served notice, all of this is irrelevant. And I disagreed. And I disagreed primarily because in my training as a barrister, I know read what's written there. And it doesn't say it. So before I came today, I thought, well, I'm a bit buggered here. Because I pushed along over the top of it last week and went, thanks for your contribution, Alex. And my finger slipped and we moved on to the next slide and off we went. And there's a few bewildered faces going, what the hell happened there? Where did that go? So I sent a LinkedIn email. And LinkedIn is fantastic for getting a hold of people, otherwise you wouldn't take your phone call. And there's a barrister in London called Nicholas Isaacs, who deals with all the party wall stuff. Very, very good. And I put this to him. And he said, no, you're right. He says, I wouldn't try and do it though, because it hasn't actually been tested, but you are right. There is nothing that says the adjoining owner can't actually invoke the Act by appointing a surveyor, asking the building owner to appoint one, and if he refuses, go through the Section 10 mechanisms, and, that one there, and appoint one for him. Building owner may like it, but you've just taken it all away from him and put it in the hands of some competent surveyors and let them sort it out. And of course the building owner will get their bills. So that's one way to deal with it. And there has been a sort of a movement towards this. And it may get to the stage which I would like to see, because taking injunctions out is a pretty heavy-handed approach between neighbours. The bill might be 10, 15 grand. for a building owner who's maybe just cocked up, maybe just didn't know what he was doing. Next thing, bang, this injunction's slammed on him. He has to pay for that, pay for all the costs. His builder's buggered off and off to another job. You know, it's cost him a fortune, and all because he dug a hole. And there's no communication. And he didn't know. He was ignorant of the fact. He was badly advised. So I think it might be a better approach to engaging the protection of the Act without being as heavy-handed. Now, of course, solicitors will only tell you one way. You know, they're not going to make any money if the surveyors are dealing with it. But if there's an injunctions, then they're in business. Okay, I'm not saying anything wrong with that, but that's their remedy, that's their approach. And I always like to think, no, Party Wall Act was written for surveyors. So surveyors should find the solution. Okay, and we should try and keep the lawyers out of it. So this Act, Crawley, Rushmore Borough Council 2009, and it said that an owner has a statutory duty to comply with the Act. In other words, he's got a duty to serve notice. Okay, that's mandatory. And if he doesn't serve notice, that's a negligent omission. Because he has a duty. And by not carrying out that duty, he's breached that duty. And if that breach, i.e. not serving notices, leads to damage on the neighbour's property, damage that was foreseeable, i.e. digging a trench, allowing it to fill with water and then going, when the neighbour's garage slides into it, that owner is liable for damages in negligence. But more importantly, it said that the surveyors did have retrospective jurisdiction. So we started off this by going, you know, the rule of thumb is surveyors don't. But now we're sort of getting case law that's sort of going, well, maybe they do, maybe they do. And it continued on. I don't want to go into this in any great detail, but there was then case law, Reeves and Blake, which went back to a previous case, which is Woodhouse, and it said only disputes under the Act can be dealt with under the Act. So what they said was surveyors cannot award compensation for unlawful works. And Rodriguez and Sokol said surveyors can only authorise retrospectively if no damage is caused. So this is quite often what we're all tempted to do, is sort of make good after the fact. You know, the two owners, the works have sort of started and they're halfway through, and suddenly the owners go, we should have invoked the Act, we forgot to, but would like to do it now. So two surveyors can be appointed, can do an award, can say, yes, everything can continue, but only if it's all finished and there's no works, if there's no damage. It's a bit pointless, because if there's no damage, why are the two surveyors appointed? So this is the legal system going around in circles slightly. So leading on to that, so I've said the importance of serving a valid notice, because that kickstarts everything. Whether you agree with me or Alex Frame, doesn't really matter. Notice. Serve notice, you're protected. If your neighbour's not served notice, get them to serve notice, you're protected under the Act. Notice or other document required or authorised to be served under this Act may also be served in person, and we know the different rules by this, and obviously this was added more recently, that only if the recipient has stated a willingness to receive the notice or document by means of electronic communication. So I know whenever I was putting out my authorisation forms, a little strap line at the bottom says, please tick this box to say that you will receive electronic communications to, and then they would fill in their email, tick the box and serve the, and then I said, well, I'm fine. Because they'd have no choice, or I wouldn't get it wrong if I started sending off awards by email and someone said, oh, I'd never look at that email account, and actually I never told you could serve it by email. And obviously the 14 days to appeal is only from the receipt of the award by the owner. So I haven't served it, the 14 days still to run, building owners half has worked on, and it's my fault. So you have to make sure the awards, if you're serving in both parties, have been properly served. But then there was an interesting case, Knight and Guldaris in 2018, and I turned all this in his head, and this is pretty recent, and it said, do you know what, this is only permissive. It's not mandatory, and in law, mandatory is something you must do, permissive is something you may do. And it said, because it's only permissive, I'll give options of, and we all know the, you know, by hand, by post, by nailing onto your neighbour's door, etc. And they said, yeah, those are all fine, but it was not an exhaustive list. So therefore, it would also have included by email, if anybody had thought of it at the time. So it's only permissive. So in other words, you can always serve by email. Okay, you have to prove that the other person received it, of course, which is a challenge. But no need to put that little strap line in the bottom of your notices. So talking about the importance of a valid notice, this is one that I was involved in, and it's in the handout if you want to sort of get a better view of it. It's case study 3, and this is standard section 6 notice and that I sent, and the accompanying plan showing the foundations. So this is all pretty standard stuff. I had an appointing owner that said he was building a rear extension, wanted me to serve the notices, didn't bother going on site, did the usual, no problem at all. I'll serve the notice, and as you all know, for a section 6 notice to be valid, it must be accompanied with the drawing showing a plan and the depth of the foundations. So that was all done. So I want you all to have a look at that just as I sort of continue to speak. Don't shout out. But this was declared to be invalid. So the little challenge is why. And this was the property that we were talking about, and it was in Wimbledon. And usual configuration, there's an old Victorian house. It's been subdivided into 4 flats, 2 in the ground floor, 2 in the first floor. As you can see, the ground floor flat on this side is roughly the dividing line there. Has already been extended. They've built a series of rear extensions. One of them seems to be on or thereabouts onto the boundary. My appointing owner owned this flat, and he just wanted to build a rear extension in this area. So absolutely bog standard. You know, there's no real problem with this. So I served those notices, and I wasn't really prepared for the storm that was coming my way on receipt of those. So rather than getting the usual reply or acknowledgement back from the adjoining owner, 10 days later, the usual stuff, I got a solicitor's letter, and it ran to pages. And I went to see my appointing owner, and I said, "What's going on?" And he went, "I perhaps didn't give you the full picture." So it turns out this guy and this guy have been at war for about 10 years. And I'm just thinking, okay, cheers, mate. You've landed me in at this time. And I said, but that's okay. We'll use the Party Wall Act to navigate our way through this, because I'm a great believer in it is a genius piece of legislation. It's there, as we said at the start, to allow you to do your works. As long as you don't inconvenience, disturb the adjoining owner, we will motor through. So it actually served 2 notices at the time, because the appointing owner thought this is a party wall and had been built astride the boundary, which meant he could make use of it, subject under section 1111, paying compensation 50% of the current cost to the adjoining owner. And I said, okay, I've looked at the plans, and why do you think that's a party wall? And he said, because Jim, who was the previous owner to the guy who's there now, said to me, I'm building a rear extension and I'm going to build it astride the boundary, but you're okay, you don't have to pay for it today, you can pay for it when you build your extension off it in the future. And he said, that was a great idea, so I agreed. Of course, nothing in writing, the act wasn't invoked. Jim, Fred, whatever his name of, is now living in Australia, can't be contacted, of no use to us. What 2 neighbours say over the fence is irrelevant, unfortunately, when there's a dispute. So this guy, the new owner, said no. In fact, it's not even a case of that's the boundaries on the external face of that wall. The boundary is actually about 1.5 meters off that wall. So he claimed there was a line of trees, and he claimed the boundary was there, where those trees, that line of trees there, which is about 1 meter off. And then later he then went, actually I was wrong. It's beyond the trees. It's the far side of the trees. So the boundary just kept moving that way. So I'd sort of serve various notices to keep myself right, because time runs, and if the notices are relevant, I can stick in the bin. Okay? So I served a section 6 notice, because obviously we were excavating Now, we probably weren't going any lower than the foundations of the extension because it was only built about 10 years ago. So the chances are we were both going down about a metre, you know, so we weren't going any deeper. But this old house, built in 1870 or whenever it was, and that I think was the rear of it there. So we were definitely going deeper than the foundations of the original house. So we served a Section 6 notice. I then wrote to them and said, but we also want to make use of the party wall and we'll pay you for it. I also served, I thought, well, if it's not there, I'll also serve Section 1.5 notice to say that we are going to build up to the line of junction. I just didn't know where the line of junction was. But there's nothing wrong with doing that. I thought, well, I'll get it, you know, that's going to run for a month. So while we're arguing about everything else, time will have ticked and I'll not be delaying the building owner's work. But this dispute rolled and rolled and rolled, and the solicitor refused. He said, no, this is all rubbish. Until you resolve the boundary dispute with my client, he will not be responding to your notice and nothing will happen. So we knew this was just they didn't want anything to happen at all. So this was just a delay tactic. This was just frustration. So I thought to myself, okay, so I served a 10.4 notice and I said, well, look, if you two, you know, ignoring the solicitor but copying him in, to the owner of flat 2 and said, well, look, in 10 days, if you don't appoint a surveyor, the building owner will appoint one for you. They came back and said, no chance, this is unlawful. If you don't sort out the boundary dispute, first of all, then you can't proceed. And I ignored this and they didn't respond, so I got the owner of flat 1 to appoint another surveyor. We then appointed a third surveyor, James Lewis. And of course the solicitor at this stage is going absolutely ballistic, threatening injunctions, threatening everything in his armoury. But we weren't stupid, there was no works going on. We just wanted to get the award sorted out. So then the work, when other things were sorted out, was all in place. So they quasi-appointed a surveyor. So there was a very well-known surveyor in Wimbledon who appeared and said, I am going to act for them when I'm good and ready. Whenever the boundary dispute is sorted out, I will then attend to the Party Wall Act and not before it. So that got right up my nose. And sort of two things went off on a tangent here. One was the boundary dispute and one was whether or not we could proceed with the Party Wall Act and get an award signed. So of course I'm really nervous at this stage because I'm thinking I've made a huge mistake here. I'm way out of my depth. I've got this completely wrong. I'm winding everybody up. The solicitor's letters are flying. The costs I know are going up. And so I thought, I know what I'll do. Before I actually sign the award, I'll refer it to the third surveyor. I'll make him make the decision. But I'll pay for it. Okay, because I'm the one that's not confident enough in my own work, you know, to make a call here. So I'll pay for it. So I sent everything off to James Lewis and I said, well, here's all the correspondence, here's all the background, here's my works, here's my appointment, or the building owner's appointment of the surveyor because they wouldn't appoint one. Here's our selection of you as the third surveyor, and I'm now referring the question to you. Is all of this valid and can I get on and sign the award? And here it is in draft. So he was very good, and for about 675 quid, he came back with an answer. And his answer was, you're fine. He said, you have a served notice, you have correctly corresponded, kept everybody in touch, and you have correctly appointed another surveyor to act because the adjoining owner just wasn't doing it, despite you requesting under Section 10. And your selection of me, therefore, as the third surveyor is valid, so I'm allowed to make the call on this. You can proceed, and you can have your award. And the award will be valid on the basis of you're only asking, can you excavate? That's fine. You're only asking, can you build, and this was the crux of it, can you build a new wall on the line of junction? Because we would accept that it was obviously somewhere on our property, or even if it wasn't true, we were quite happy to agree a boundary line and build up to it to sort of minimise the disruption and get on with things. But the only issue was we just didn't know where that line of junction was. And this was the argument of the other surveyor, is you can't make an award to say you can build in the line of junction if you don't know where it is. But as surveyors, it's outside their scope to say where the boundary line is, so of course we could. You can build up to the line of junction once you find it. So that's what we did. But then he came back to me. Oh, sorry, that was all looking good. And then I read the other last paragraph, and he said, however, your Section 6 notice is not valid. So everything is okay, and you can build your wall in the line of junction when you find it, but you can't excavate for foundations until you serve a new notice. So my question is, why was it invalid?
Longitudinal section, not a cross section.
Show the location of it, that was all okay.
There's no depth on there, was there?
Yeah. So there's no depth in the foundations. Didn't say how deep they were. You know, the sort of the little beauty that always sort of says a minimum below ground level subject to building control inspection. Wasn't there. I'd never looked at it. And that in itself, I wrote back to him and said, that's fine. You don't have to. There's a scale in the drawing. The drawing's a scale. I mean, where's the scale? There was no scale. So I'm sorry to the architects in this room, but hey. There was a guy who knew what he was doing. He was taking no liability for anything. So unfortunately there was no scale and there was no annotated depth. One or the other would have been fine. So the Section 6 was invalid. So in the end, that had to be, well actually in the end, this guy brought it all the way back to here and built it 3 metres away, so he didn't have to invoke the Act at all and get on with his building. Which is a sad state of affairs, because then, about 2 months later, the boundary dispute was resolved. And what they discovered was that this is his wall, this is the dividing wall, and this is what he wanted to build. And actually the area in yellow shows where the adjoining owner had actually already built the wall astride the boundary. So that was correct in the first place. But if you can't get people to buy into something, if you can't get agreement, where do you go? My advice to this guy was wait. Okay, I'll serve another Section 6 notice. It'll go through the course. There's nothing to object to, so you'll have to wait another month. He was under pressure from the builder to start ASAP. The boundary surveyors hadn't got round to agreeing where the boundary was, so he just went on with it. My advice, obviously, stop, wait till they determine where the boundary is, then you can go on with the works, and by that time the Section 6 notice will be there. So this was the wall, so you can sort of see this was his existing rear of his building. This was the other flat. This was the wall in question, and they had got to the stage, this was a little bit further on, where they had removed everything and they actually ended up digging the new wall back here, so they didn't have to invoke the Act. And those are the issues that I came across. And again, this is bog standard, so I thought this is no problem, this is nice and simple. But in the end, solicitors got involved, the whole thing went off the wall. They said it wasn't a party wall. They actually said the boundary's way back here. Their surveyor refused to act. I then had to refer it to the third surveyor, which I'm glad I did, because I was wrong. Yeah, and it's just important sometimes, if you're not 100% sure, ask. And that's the whole point of the third surveyor. It's not just for the building owner and the adjoining owner to ask just before they're at court and have already paid 10 grand each and fighting each other. Ask quick, get an answer, and then it's his problem.
So who paid for all that?
I paid for the referral. So the only bit that I was interested in was my advice was sound, and I didn't tell anyone to start. And my advice was wait until all the way through was wait. I just wanted to get the award settled and out of the way, so then somebody else could deal. I wasn't dealing with the boundary dispute. Somebody else could deal with that. And then once that had come through, which it did in his favour, then he could have got on with his work. He was the one that decided to jump the gun and start the works. But I paid for the advice to the third surveyor because I was the one questioning my own advice.
So did the building owner pay your fees?
He paid my fees. Yeah.
Bearing in mind, once it's moved away, it's no longer party wall. So
I had agreed a fee with him at the outset, and the party wall was invoked, the Act, because I'd served a valid Section 1 notice. It was just the Section 6 that wasn't valid. So he ended up having to pay my fees. He had to pay the other surveyor that I appointed he appointed for the adjoining owner. And the only thing I paid for was the referral to the third surveyor.
So the neighbours, solicitors' bills and things like that?
No, because obviously they reached agreement in the end. And it was one of those where both solicitors, both surveyors, these are the boundary surveyors, all stood on site and they shook hands in the end, came to an agreement to the detriment of my guy. But they came to an arrangement, shook hands, and that was in full file settlement of everything. So very expensive dispute, very expensive dispute. But you know what? And I turned around to, at the very end of it all, building owner, and in fairness to him, he was a nice guy, paid me, there's no problem. I turned around to him and I said, if you just told me the truth at the start, I wouldn't have gone down the path that I went on if you just told me the guy beside you was going to stop your work at all cost. And actually it then transpired that already had a conversation about this wall and the trees and all sorts of things. And what I didn't know, there was fir trees here, and they actually were all along here. He had cut them down, and that's what started the dispute. Okay, so sometimes it's just keep your eyes open, but ask, have a chat. You know, it's not like a cup of tea to find out the true story of really what's going on. So just going to chat about party walls a little bit because it's important. I discussed, and this is yes.
Sorry to before you start on the next bit.
Yeah.
People sometimes don't like the advice they get.
Yes.
So in that case, there was 1, 2, 3 party wall surveyors instructed.
Yeah.
If any time either of those parties don't like the advice of surveyor 1, 2 or 3,
yeah,
what is their recourse? Or can they reappoint?
They're not allowed to reappoint. No. Once you're appointed, you're in. For that very reason. Yeah. That if one of the parties goes, do you know, I just don't like that advice. The idea is that party wall surveyors are impartial. Yeah. And it's really important, any of us that work as party wall surveyors, is that we are impartial. We don't act, we're not, they're not our clients. They're our appointing owners. Yeah. And we have to be impartial. And I must say, I work in London, but I've only maybe in about 5-6 years now, really getting stuck in party walls, ever found one surveyor who's excuse my French, a tit. Yeah? Most guys and girls get on very well, and if you make a mistake, you get a phone call going, would you not look at this? Have you considered? You know, and it's all really helpful. And then ultimately there's a united front to both owners. Obviously, and I've had this happen as well, if they don't like it at the end, they've got 14 days to appeal to the county court for them to look at it. But ultimately it goes there, and you know, the magistrate's sitting there, the judge is sitting there and going, well, sorry, 2 surveyors have said this. What on earth wouldn't you? You know, there's nothing in here that's unlawful. You just don't like it, go away. You know.
Thank you.
So this was just to have a quick look at actually party walls for anyone who's not au fait with it. There's 2 types. So your sort of typical type A party wall is where the wall is severed vertically, and in the middle of that wall is the boundary. So it's built astride the boundary, as we say. And that can either happen where this house was built astride the boundary. It's an independent building, they just didn't use that wall. They could have, they have the right to make use of it. They just built their house inside it. Your typical semi-detached or terraced houses, where it's the dividing wall is a party wall, the boundary is the midpoint of that. Or you can have instances of type B party wall, where actually it's a party wall, but the boundary is on the outside face. And that's typically where one house was built first, a little bit like in this scenario, but the next house was built up using, with the permission of this owner, they've used that, and then it becomes a party wall, because they're paying for it at a later date.
So I was going to say, they have to pay for half the value.
Yeah, so now, sometimes it's done outside the Act, but if it's done under the Act, you can make use of a party wall, and it's section 1111, but it's subject to you paying the person who built the wall 50% today of the cost. And the legal reasoning behind that is, if you're building a wall astride the boundary, you know, half on either side, then presumably, because you need the consent of both parties to do that, that would only be done, and in the sort of theoretical world, they would both pay for it together. They would jointly build that wall. But in practice, one person doesn't want to make use of it at the same time, so they can pay later on.
So it's 50% of what cost? Is it the cost of fines?
The cost of the foundations, the wall. So what? Yeah. So.
If you're subsequently building, taking advantage of that clause, is it the cost of fine?
No. So it's the cost of the wall that was built 10 years ago, at today's prices. So it's the old. Yeah. So it's the old wall, but today. So it's the day that you want to make use of it. And this is the sort of the law in this one. I'll just have to refer to some notes to get this right. But it's section 38 of the Law of Property Act is the one that states, I'll never find that now, is the one that states that actually it's the midpoint of the wall is the boundary. So that's very useful if you're doing disputes about boundaries and rear gardens, and your houses are nice little terraced houses. Land registry shows nice rectangular lines behind. You can be pretty damn sure when you go to that house that if you can work out where the middle of that party wall is, the wall that separates those two houses, the middle of that is the boundary. Okay, and that comes from section 38. So if there's no evidence to the contrary, the default is, the presumption is that it's the middle of that wall. So when we've looked at party walls, you have to have a working knowledge of boundaries to be a party wall surveyor. You don't have to be an expert, they're two different disciplines, but it's good to have a general knowledge, and that's what I just want to sort of run through a little bit today. So party fence wall, these are sort of definitions. It's a garden wall that sits astride the boundary. So built jointly between the owners, with the boundary being bang in the middle. I'm sure you're all very familiar with the idea of fences, and that you give, in theory, your neighbour the clean side. Now, this is not because you're trying to be nice and you want them to sort of see what a tidy property you have, but your boundary is the outside face of the fence. So therefore, it's common sense to say that you'd have to do all the building work on your side. So you have to put the fence posts on your side and then put the panels on your side with the face to your neighbour being the boundary.
Does your neighbour have to pay for half of that?
Not in that scenario, because you're building a fence wholly in your own land, and your fence, in that party fence wall, yes, because theoretically it's a joint. In practice, of course, people don't always do that, but in theory, yes, the law will always assume that you jointly paid for it, now or through the act later on.
Can you force the person to pay?
Yeah, there is, under section 2 of the Act, if you have, for instance, a party fence wall, so it's a wall sort of running out from the back of the houses, jointly owned on the boundary, and one of the neighbour wants to use that wall to build his new extension off, under section 2 they can serve a notice to raise or thicken an existing wall, and it includes a party fence wall, and that's why I was giving the definition of it. And obviously if it's in need of repair, you can send a bill for half of that to your neighbour. But normally, if you're the one making use of the wall and you want to do it for your own purposes, why would you start? Exactly. A boundary wall, conversely, would be a wall in your garden that's all in your side, completely in your side. The outside face is the boundary. An external wall, therefore, is when you have built your rear extension, and again, the outside face of that wall is on the boundary. It doesn't go over the boundary, it's right up to the boundary. The issue with that, of course, is what do you do for maintenance? Very, very important in London, where everybody's actually building on top of each other at the moment. In the last 5 years has been incredible, possibly because nobody can sell their house. So interest rates being cheap, everybody's adding to extending their houses, and everybody wants every last square inch. That's all well and good, but you can't get round to anywhere, you can't get round to point the wall without the permission of the neighbours, etc. So the Party Wall Act allows you to do some of that. Failing all of that, the Neighbourhood Land Act allows you to go, you have to serve notice, etc., allows you to go onto your neighbour's property for maintenance, if it's maintenance that's required for your building. Just very quickly, remedies for unlawful works. So if your neighbour's done some building works that they shouldn't have, you can take it on an injunction, or you can sue for damages. But there's obviously certain criteria here. A court will allow you obviously want damages, but you have to be able to prove that you can get them. And the leading case here is Ruthven Park Estates, and it's known as Ruthven Park Award. What the court said, in essence, was the more you get is determined by the bigger the fault. So if your adjoining owner has done something terrible, you get more money. If they've benefited from the infringement on your property rights, the award is bigger. If it's to your detriment, the award is bigger. So just moving on then, I'm just going to go through a few case studies. And this was property that I looked at in Balham. And again, pretty straightforward. So this is my appointing owner's property. This is the property next door. And they had built a little rear extension here. And later on they built a little mews house here. This was the alleyway between the properties. And my client wanted to build a little infill extension here. So that was all pretty straightforward. And my first question was, well, what sort of type of wall is that? Because that's going to determine what I do next. So I managed to dig out the old planning drawings, which clearly showed that this wall was built astride the boundary. Not that that's definitive, but at the end of the day, that's this guy's drawings. So, you know, why would he get them wrong? And a little bit more investigation, I was able to find out that this had actually been a party fence wall built astride the boundary. There's no argument over that. It was written up in various documents. He knocked it down and used it as the external wall, rebuilt it again, but enclosed off it to build his extension. So that was all straightforward enough. This is a little picture. So that's the alleyway between the two houses. This is the Muse building that he then subsequently bought. This is the little area in here that my client wanted to build their extension. So again, I thought this is really easy. We'll just serve notice, we'll enclose off their wall, we'll pay them the compensation, he'll be happy, he's getting a few grand, and it'll all be, you know, pretty straightforward. I mean, we're going to keep the alleyway here, we're literally just going to fill this little area here at one story. You know, couldn't be simpler. Unfortunately, that was the furthest from the truth. So I arrived in the site, and I'm just aghast as I'm looking up this alleyway and see all the property infringements that are there. A door coming onto our alleyway, a window overlooking, I shouldn't say our, my appointing owner's alleyway, and various bits and pieces, drains, gutters, flues, all sticking out. I'm going, okay, well the one thing that's for certain is we can't enclose on a wall that's got a door and a window in it. So we're going to have to sort of think a wee bit more laterally here, see what we've actually got. So the first thing I did was took a step back and said, okay, let's, in my own mind, I need to be sure that actually this wall is a party wall astride the boundary. This comes from a really great website. I think it's John Maynard. He's boundary surveyor down in Southampton. Look at his website. Anything you want to know about easements, boundaries, rights of ways, Party Wall Act, absolute encyclopedia. Great guy. And I've just stolen this because I was easy to draw my own. So if you need to measure, looking back at section 38, which said the midpoint of the wall is the boundary, so you're trying to determine where that boundary is, just take measurements on the inside from two openings, so from the door reveal to the wall, from the window to the wall, come back outside to the rear wall, mark those either side, and bang in the middle is where your boundary is. Okay, you all know how to do that. It's all pretty basic stuff. Great for terraced houses. And then of course we're having a look at these issues. Once I've determined, and then I saw that, you know, we had documents that said it was a party fence wall, etc., and I thought, right, fine, definitely he's rebuilt what was a party wall, so it's still a party wall, and we have the right to use it. So I started going, right, I need to categorise all the issues here. One is where the boundary is. I'm quite happy, I know where the boundary is. It's a party wall. But what are we going to do about this window? What are we going to do about the door? So with the window, he said, no, I have right to light. You can't block that window. I use that window. It's the only light that comes into that building, this rear extension. You can't move that. The door, he said, oh, but I have a right of way over the alleyway out to the Muse at the back. You can't block that. That's my right of way. So having a little look at these, and again, the law to a lot of this is in the handouts. I'm not going to go through it now in any great detail. But the first thing I thought was, right, what rights could he have? And I have it in, I'll go through a few others and then I'll go back and sort of tell you how I dealt with them. A couple of other things that we've mentioned on, there was a flue sticking out of the wall. There was gutters, rainwater, flowing water coming down. Again, all projecting, because we've already decided that this face is the outside, is the boundary. Okay, that face is the boundary. So anything that projects over that is a trespass. It's just pure and simple. Shouldn't be there unless there's a right. So as far as easements are concerned, so that's your right to have something like a projection. The right to light, right of way, or right to running water. So these are the issues that we looked at. All come, most commonly, there's other ways that these can be made, but under the Prescriptions Act 1832. And you probably all know that that just says if something has been used for 20 years, then it may form the basis of an easement. And an easement is a right of one person over the property of another. It could also be more commonly made by deed. So it could be an express right, where actually you have a contract and it says there's a right of way and it runs from A to B. Dead simple, it's in writing, signed by both parties. That's immediate, that's there. But failing that, under the Prescription Act, you may have gained that right, as if you'd always had it, by having 20 years use. Thankfully, the extension was only built 10 years ago. So it'll immediately say, right, there's no right to light then. They haven't got the 20 years. There's no right of way. We looked at all the deeds, his and ours. There's no mention of it whatsoever. There's no right of running water. Again, you can have it after 20 years. So if gutters are there after 12 years projecting, you have you can get it by adverse possession. So you have a right to leave that gutter there. 20 years for the right of running water. So if you don't, if your neighbours built their extension right up to you and there's all these projections, get rid of them, because eventually they'll have a right over them. And there's no right to the passage of air, however. So the air bricks at the bottom of a sort of a house with suspended floors, and it's built right on the boundary. And I came across one recently where one owner wanted to, enclose off that, which was a party wall. And the other surveyor came up with this plan of how all this air was going to get under the floors. I just went, no right to that. You're not having it. Shouldn't be there in the first place. We reached a compromise, but he was just being too bolshy in the start, claiming something that he had no right to. So one by one we managed to get all these knocked in the head, that he didn't have the rights that he was claiming. And it turned out his rear extension, the reason that he wanted the right of way and the right of light was because the regional planning drawing showed roof lights on the flat roof to get the light into the building, and he was just too tight to put them in, and it was cheaper to knock a window in the wall, which he did after the construction. And the doorway was because, now I'm no building control expert, but I know if you have an office off an office off an office, you need a secondary access. He was a solicitor in a solicitor's office, and his third office had no separate access. So we just put the door in. So when the council came round to give him his building reg sign-off, or his fire regulation sign-off, I think it was, they saw the access. They went, that's fantastic. Here's your cert, all complies. And it turned out actually the door was blocked up on his side, never been used. But he brought the guy round and said, there's the door into the office, now come this way. And it was enough to get it signed off. This, of course, is what you want to see when you've got an easement. You don't want to have to try and work out whether someone's gained it over 20 years use or not. This is just absolute standard. This is someone's deed in a conveyance. This is the road. All these houses had to get some way and some mechanism of getting on the road. So this area, the sort of the common road, if you like, unadopted as it was, in front of all the houses, under the highway, was just full of rights of ways. My client, this guy was parking his cars along here, and my appointing owner came to me and said, he's parking his cars and I think it's on my land, can you get him to move it? And in the end we did, and not because he was on his land, but because he was parking on a right of way. And the right of way was enjoyed by about 5 different houses, and this whole area, blue and red hatched, was all one big right of way. So no one can block it by parking. Okay, so much to the angst of my client, because he parked his cars here, and I unfortunately banned everybody from parking the cars anywhere. So I'm never allowed in Windsor again after that one. It was one of those sort of consequences of giving great advice and thinking you're a genius, and everyone then telling you to bugger off afterwards. So I think they've just all ignored me and they all parked the cars there again. But I got asked the wrong question. That's what I say. So in that previous one, the property, establishing the external wall was a party wall, was a key to everything else that followed. And I must say I was very surprised. It was never challenged. The adjoining owner accepted, yes, there was a party fence wall, and yes, I knocked it down and rebuilt it. Okay, that was his mistake. But that allowed me an out to actually solve a lot of these problems. Because there's one thing identifying, you have no right to have this, but what are you going to do to remedy it? You know, what are you going to do so your works can actually proceed? So in this instance, what I did was I realised he had no rights, therefore they shouldn't be there. But the lawyer said, I think they gave a 30% chance of, at court, getting him to close the door and the windows. At a cost of, I think it was 35 grand, was what they estimated. This is one of the big law firms. And I'm a little bit, really? So I just served a Section 2 notice, says we're going to enclose off your wall, and the building owner has the right to underpin, thicken or raise a party structure, a party fence wall or an external wall which belongs to the building owner and is built against the party structure of the party fence wall. So basically, the thicken allowed me to brick in the window and the door. And again, I wasn't sure about that, so I asked. And I asked Alistair Redler, who was doing a chat, as he does, he goes round, very, very good party wall expert. And I called him at the end and I said, this is what I want to do, can I do it? And he said, yep, Section 22A, thicken a party wall. You have the rights. And we did. And thankfully, at this stage, the building owner, or sorry, the adjoining owner, who is a solicitor, realised that we'd got him, if you like. The party wall, well, it was his surveyor agreed with me, it was all signed up, it was there. He didn't appeal it on time. I think he wanted to, I think he just forgot at the time. And then we went in and he said, no, I'll do it myself. And he had sort of admitted if he'd bricked it up, and that was fine. And we built our extension off it. And he got a cheque for us using his wall, but which meant himself and the other surveyor. So the importance, again, you got really difficult parties. The two surveyors can go away with cool heads and say, well, actually, what does the law say? And then tell the owners, this is what's going to happen. They've got the right to appeal it, you know, but you have to sort of make your case.
I'll ask you a question. What happened about his central heating? He got the flue out. Did that have to be...
No, we actually gave away. No, we let him away with that one. Because we weren't going to use the external wall was in two bits. Right. The old extension and the new Muse house. And actually, there's the projection. They were unlawful, and I did actually serve a notice under Section 22G to cut away from a party wall any projections. Right. So we actually made him rerun his gutters. So we did that. But the flue was so high up, and I think because he had sort of agreed to everything else, the building owner just went, you know, there's only so much you can do, and you know, and again, I think that was a sort of a decent gesture at the end to not completely be, you know, idiots about the whole thing.
So with that cutting away of projections,
yeah.
do you have to put back something to take the place of the bit you cut away?
Well, you have to make good, so you couldn't do any damage to either, you know, because the wall is half your neighbours and half yours. If they're refusing to do it, you have the right to cut away. And obviously in those instances...
So if you cut the flue away...
Yes, well, we'd have to brick it up. What he does internally in his property.
To rerun the flue, it's his property.
That's in his property, that's completely up to him. So he would have just had to run it straight up through the roof. But yeah, you have the rights. It's a little bit like, you know, when you have projecting foundations and you're looking to build against them, you have the right to cut them off on the line, as long as you don't, by doing that, cause the neighbour's property to fall in on top of yours. So you have to sort of balance these things. But you do have the right to do it, and that's, again, for the projections, rather than going to court and rather than asking some judge to tell him to remove all this stuff, we just serve the notices saying, well, we're building a new wall, you know, we're enclosing in that, and we're actually going to build a new skin against that, so they're all going to go. So either you move them or we'll move them. In the end, he did. But it's a good example of how the Party Wall Act was actually what allowed us to get all these, to actually push these things through and kept us out of court. Boundary disputes, favourite of mine. How much time have we got left, JJ?
Fine.
Sorry?
Fine.
Fine, okay. So boundary disputes, and one thing leads to another. So with party walls, you need to define where the boundary is at the rear of the house or the front of the house. But also then you've got gardens, so you need to have a look at where it would be. So the leading case for boundary disputes, Alan Wibberley, and that was Lord Hoffman, and he sort of set out the rules about boundary disputes. And in a nutshell, what he said was, if the plans and the deeds, so that's the plan to the deed, is clear, that's it. That's your legal boundary. There's no need to look any further. All this chat about, oh, there's an old boundary fence and there's an old post, and relevant. Okay, This is a contract between a buyer and a seller. And one person said, I will sell you this for this price, and this is what you're getting. That's the contract, okay? So there's no need to look at anything else. So in this instance, this is a property in Hampton. The owner of number 60, their land used to be all of this. They divided it in two, and they sold this plot off in about 1950. This was 1937, I think it was about 1954. They sold off this plot, and they very nicely put lots of measurements on it, so it could be easily identified. Purpose being, when the guy bought this, he could do his measurements and work out what he owned and what he didn't own. Scarf versus Adams then, it also said, look, if the plan is clear, that's the end of it. You don't need to go looking any further, okay? And the main sort of area to look for is when you look at it's called the parcels clause on a conveyance. It's the little bit that describes the land. Now, it might just refer to a plan, might go into huge detail of descriptions. And the key to it really is if you have a look, and if it says on the plan annexed here too, you're on a winner. Because it's saying that's the land. Okay? Yeah.
Just one question on that one. I dealt with someone recently, and it was clear in the lease documents where the boundary was. There was a measurement from a specific point, but the boundary wall, when the development was done, wasn't in that direction.
I'll come on to that a bit next. So this is the theory. Now, as we all know, when's the theory ever been any use to anybody? So, if it says on the plan, that's it, definitive, brilliant, thank you very much. If it says for the purposes of identification only, it's of no use to you at all. It's just going, it looks something like that. And then you have to go further and you have to actually go, what's here? Where is that fence? Has that fence moved? Has that fence been here for the whole time? And then that's extrinsic value evidence, looking at all the other things as well. Land registry plans are of no use. Never look at a land registry plan other than for the purposes of identification, going, it's a rectangle. It's here, it's there. Okay? If you took the red line on a plan, which is normally about 1 to 1250, put it on the ground, it's about a third of a metre, which is about that. Now normally disputes are between here and here, so it's of no use to you. And unless it's been determined under, I think it's section 60 of Land Registration Act, it's got no legal standing. Okay, you can't turn up and go, there's my title deeds, that shows what I own. It doesn't. And it's deliberately not supposed to. It's deliberately not supposed to. The problem historically was, this was great in the 1930s. Everybody had conveyancers who drew lovely plans. They employed surveyors who actually took measurements correctly, put them on a plan, annotated. They went in the back of deeds, which everything was there. It was all there. And then, of course, everything went digital. Every land registry started taking records of everything. Land started getting registered. And solicitors with all their big boxes just went, didn't physically throw them out. They wrote to the owners and said, do you want them or we'll throw them out? And nobody wanted them, so they got thrown out. So a lot of these old deeds, unless they're in your attic, just don't exist, unfortunately. And then, of course, Land Registry said, oh yeah, I know we're keeping all these records, but they don't prove anything. Okay, so all these disputes that are happening is just because we did have good records, we don't anymore, unfortunately. So this is the same. I had a little problem here, and then I measured we were saying the boundary was, as per this deed, right up to the chimney, external chimney breast of this property, and then their surveyor measured it and said, no, look, there's a good metre between one and the other. And the issue all arose between the measurement between this point and this point of those houses, and on the plan it had said it's 50 feet. So he measured, if you can see there, 50 feet from one to the other, nice and clear. He measured 50 feet from this house and got to that point. Stopped shy. Said, I've even gone an extra inch, as you can see. Stopped. I think this was actually, I did this one the other way around. And it's his plan that I've just put on. And so we were arguing over that bit of land. And unfortunately what happened then was this is it, this is the argument. This neighbour decided, I've enough of you two arguing, I'm just repositioning my fence and it's mine. That's the end of that. He just took it. Simple as that. So there's the boundary line that used to run between the two houses. This is it coming up here, and he just repositioned this fence all the way up, all the way down to the back, and hey presto, he had now side access to his house. So it was obvious why he was doing it. So it sort of went, okay, there's more to this. Why does the 50 feet not work? I wanted to know what's the problem here. We'd lost a foot. He'd ended up taking a metre, but it was a foot that we'd been arguing over. So I went back to measure the other side, and this is extrinsic evidence. This is actually looking at what's on the ground. When the theory doesn't work, what's there and what does that tell us? So I went over to that other house on the other side, and if you remember, this line seemed to go top to bottom up against the wall here. But the interesting thing is, this house hadn't been built. Okay? So whoever drew that on was going, this is obviously where this house is going to be built, but it wasn't built. So that was key.
How did you find that out?
It just went through land registry. Hadn't been sold, it was open space. It was belonged to the property in the next door. It was the same idea. So just the house that was there just hadn't been built. Whenever our house was built, it just wasn't there. It was land registry. You can see when it was sold off, the house in the other side. It was a vacant plot. It was their garden. Never been built on. And so I went over and had a look, and then I realised I found my missing foot. Because the boundary fence ran up to the front of the property and then came in a foot up against the gable, because obviously what's the point in having that sort of space off the edge of a house? You can do nothing with it. They just hadn't bothered putting a fence there. The fence came to the front and the back of the house. And even this little wall, there's a gap there you can barely see, but it was a foot. So it kept everything off. So the guy had built everything up to his boundary and stopped. And then this house was built. And this house was built, and they didn't go all the way to the boundary, they just stayed shy of it. So we found our missing foot, if you like. So trying to sort of make logic behind the theory and what you find on the ground. And that was only the start of the problems, because then once we worked it all out, and we actually did a proper topographical survey, I'm not a land surveyor, so if I'm doing boundary disputes, I always engage a land surveyor to do me an accurate plan that then I can interpret and work off and layer things onto. And what we worked out here was, at the front of the house, this guy had stolen that amount of land, but actually over the years this guy had stolen that amount of land. So this is getting back to your point of, sometimes you do too much work and you actually find out it's not what you want to see. So this was very simple. So we all sat, we had a mediation in the conservatory. We sat in the conservatory of this house, neighbours sat in the conservatory of that house. And the great thing is the mediator was there, was a retired judge, really good guy, got to the bottom of this, looked at the surveys, was very happy with all the evidence that was put in front of him, agreed with me about the missing foot, thank goodness. Nothing really turned on it. Bottom line is they wanted this bit of land, and obviously both owners wanted to rectify this. So in the end what we agreed was we sold them that bit of land. Because it turns out my client in this one, it was appropriate, it was his dad's house and he was going to sell it. He didn't really care what the boundary was. He just wanted it settled. He just wanted the dispute over so he could sell it nice and clean. It made no difference to the value of it. So he ended up selling this. I think I valued it at about 25 grand, giving access to the rear garden for this house. It's probably worth about 2 mil, so you're talking big money here. And then at the same time, we took all the fences down and we agreed a new boundary, myself and the other surveyor, and put on this guy, as part of the resolution, put a brand new fence all the way down the boundary. Everybody was happy. So the mediators drew up a legal agreement, putting down the wants of both owners. That was put into what's known as a Tomlin order, which is what follows mediation, legal binding agreement. And that was fine. And then that was sent off to land registry. Land registry aren't really interested in boundaries of this size, but it goes in the back of both houses' deeds, the title register. So if there's a dispute in the future, it comes out. It's there for anyone to see. Both parties sign it. That's the end of it. Because agreement between parties create new boundaries, and that's all there is to it. So obviously, what had happened over the years is this person had gained this by adverse possession because it had been there for so long. This had been gained by adverse possession. It was just purely over the years the fences fell down and put in the wrong place. And the person putting up the fence just went this way a little bit and hammered in his post into some virgin ground.
So does the 20-year rule of like, does that never apply on boundary disputes?
It does. So it's 12 years. So adverse possession, and it's a bit further on, but I'll cover it now in case I run out of time. So with adverse possession, well, maybe I'll just skip straight on to it. The adverse possession, lo and behold, we're here. So this was a house, a nice rear garden, garage at the end. All pretty standard stuff up in Stratford. This was the rear garden, and the garage was demolished. It had been sold off, actually off. This was all one title at one stage. Sold off in the 50s, the different owner. They built a detached house on it, and this wall remained. They built a little alleyway here. All fine. And then one day, the developer who owned this wrote to the owner of this and said, "That garden's mine." So they employed me and said, "But that's our garden. How can he claim it's our garden?" So okay, let's have a little look through this. And it's very standard. This is my client's semi-detached house. This is the new house that was built, and he's now saying it's also his land. You know, so we're like, well, how is it his land? On the face of it, it looks a bit dodgy. So this is the little bit of land that he was claiming, and in a nutshell, he was correct, because the land registry showed that while this was all one parcel of land originally, the owners of number 1 had sold the garage and the garden off. But this person bought it at an auction. And he obviously stood at the back and said, "That looks nice." Bought it. So he never bothered looking, never bothered reading any of the title pack. So he actually didn't know he owned this land. Nobody knew he owned this land, but it was right there in the title deeds. So he knocked this garage down and built the skinniest little house you've ever seen, which in fairness to him he didn't have to do, because he had more land than he thought. And then it was obviously when he sold this off that the solicitor said to him, "And what do you want to do with the garden, the other bit of land?" He was like, "What other bit of land?" Discovered legally he owned this. So with adverse possession, and just quickly when I finish off on the law, before there's a new law come in, I think it was 2003, now you only have to show, so it used to be historically you had to show 12 years that you had adversely possessed your neighbour's land, that you had exclusive possession to it, you kept them off it and you treated it as your own. And the typical scenario is obviously a little bit of land, you fence it off, you put a gate in, you've got the padlock, you've got it, you keep the actual owner off it, normally because they didn't know they own it, you use it, and after 12 years it was yours. And you didn't even have to you didn't have to do anything to claim it. In law, the previous owner, as they were now, held it in trust for you and used the squatter where the new owner. And that was it. It's your land. Simple as that. So in 2003 they brought in a new act trying to regularise this a little bit, and this is only for registered land. And it said now it's only 10 years. But after 10 years of adverse possession, you can now register your right to own the land. You can basically put a claim forward. But the problem is now, I think I've got your land. I now have to write to you and go, "By the way, I'm adversely possessing your land." So the first letter you're getting back is going, "Clear off." That's the end of it. It's been disputed. So unless you as the squatter knows the person's not there, and there's no one living at the registered address and title, you know, on the land registry to service it, then you're okay. But otherwise, you know, if you're trying to steal someone's back garden, if you're trying to say the fence moved, you serve them the notice and they go, "On your bike, son." That's it, your claim fails. So really, really hard now to get adverse possession since 2002 or 3 when the law came in. So basically, if you rewind, the fence would have need to have been where it is now since about 1990 for you to get adverse possession, or before. So historically it's there, and the typical scenario is, you know, you buy your house, the builder puts the fences up, no one quibbles, it's in the wrong place, he's only a bloody fencer, he didn't give a damn where the title said the boundary was here somewhere, built a straight line down. And if it's been there for, you know, since before 1990, that's it. It's now, can't be moved. So the legal title that I started off talking about, and Lord Hoffman going, "It's clear, it's in a contract. Are you all stupid?" There it is all well and good, unless the fence that divides it has actually been there so long that your neighbour has actually possessed that land. and now it would be unlawful for you to move it back. So the key is that sort of 1990 as a rule of thumb. So if you know it's ancient, leave it. And if it's any...
Well, it was built in 1960, this house, but the wall was built in the wrong place.
But it's now in the correct place.
Of course. Yes, but not for my client.
No.
For the next door.
But your next door neighbours need to make the claim. So
Well, they've never made
no,
a claim.
and they have to. So it's all well and good. Now a court may decide no, your client is actually holding it in trust for them,
Yeah.
but they have to make their case.
Okay.
You know, which they probably successfully could. But you have to show that you had ownership all the way back. Now, not just you, but you and your predecessors in title. So you have to show that when was that wall built, and you have to show ownership. And I can write to you and say, I bought the house off you. Do you remember the wall was there? Great.
Yeah.
Write your affidavit. You were there before him. Not always that easy, you know, to get that sort of timeline back. So it's not just you that has to show the 12 years. You can add predecessors to that timeline.
So if the house was built in 1960,
Yeah.
and then the new owner comes in, say, 1990,
Yeah.
and now we're at 2018, but the wall's still in the wrong place, but
I would
the measurements
say
show-
now, unfortunately, the wall's in the right place.
Yeah, that's what I was worried about.
What happens if you sell a house and you've got a piece of land adjoining and you say, okay, well, you haven't got a garden, you can occupy my land as your garden.
By permission.
Hmm?
You've given permission. It's a license. It's a personal license between you and that person. So they can't claim they dispossessed you
Yeah.
because it's yours.
You've got to have documentary.
Well, you need to prove it, but like everything, you have to prove everything, and even your witness statement saying this is what you did is evidence.
Yeah.
It just depends what evidence they have to counter it. But normally, if it's by a license, it's an agreement between two people, you know, and the reward for that contract may have been that, or that license may have been that they were responsible for cutting the grass or maintaining and you show that they cut the grass. Oh, yeah, there you go. That was, you know, that's what I got for my contract. They looked after it. So, you know, that's good evidence, and that would defeat it if you can prove it. So, just really in conclusion, agreements by the parties trump everything else. It doesn't really matter what we think. If the two parties agree, which often they do, because that example that I gave you about we all sat in mediation, one of the things you have to do at mediation is disclose the costs that both parties have incurred at that stage, only so you can agree to pay your own costs. So the costs of my client at that stage were 20 grand. The costs of the other side were 80 grand. So it just shows you how things can go completely out of hand. And I didn't need to get to that. If the surveyor and I had met day one, we would have sort of had a look at it. We were arguing over a foot, but we actually saw there was bigger problems than just the foot. And it all came down to, no, they were, you know, even if it was a foot, they weren't going to get the side access. So they wouldn't have got that. We'd have realised the fence was all over the bloody place anyway. But an agreement could have been reached, and the neighbour could have said, okay, I want to buy this. Could have been done completely differently. And the 80 grand he spent, my client would have given him half his bloody garden for 80 grand. So just to wrap up, thank you very much for having me. For those of you involved in party walls, the new guidance from the RICS is out, 7th edition, and it's effective from the 1st of January. So they've simplified the awards, they've simplified notices, it's all there, it's on iServe through the RICS, so I recommend you get a copy of that. Thank you very much.